let me just show you the booking confirmation. In case he comes back, we'll take care of him. So this is just take down the reference number.
Okay, I'll just screenshot this as myself.
I just imagine though, you screenshot and send this file, then you show the guy on your phone, then he's cannot.
He doesn't trust it. This is a photo. Where's your paper? Where's your paper?
Maybe if you print it out and show him a paper printout, he'll be satisfied.
So then you ask, where's the chalk? Where's the signature?
He signed it.
Is Ishan coming?
No.
Okay.
Have you pressed the thing? Yeah, I pressed it.
Who's signing?
Me.
Good afternoon, Mr. President, Your Excellencies. My name is Sheikh Siraj, and I appear for the prosecution in this matter. I will be speaking for the next 19 minutes on the prosecution's first two submissions. First, on the preconditions for the court to hear this case, and secondly, on the rapes committed against Lowlands women and children. My co-agent Stella Chen will then speak for the next 19 minutes on the prosecution's final two submissions. Thirdly, concerning the unlawful transfer and displacement of lowlanders. And finally, the destruction and seizure of lowland cultural property. We respectfully reserve 2 minutes for rebuttal. Your Excellencies, in the aftermath of the Midlands invasion, countless women and children are systematically brutalized and raped. Thousands of lowlanders are displaced, and lowlands cultural property is largely lost to posterity. Somebody has to be held to account for these crimes, and the prosecution contends that the accused is the right person to impute individual criminal liability on.
Counsel, this seems like a strange way of framing it. It's like you've got some terrible thing and you want to pin it on someone now. Is that really how a criminal court works? Isn't the question just whether this person did the thing and not whether he's the right one to pin the blame on?
Your Excellencies, if we may elaborate, we contend that he's the right one to pin it on, not merely because we need to find somebody to pin it on, but because the crimes directly result from the exercise of, or the failure to exercise, the command and control that the accused had over the perpetrators by virtue of being the commander in charge of the Midlands invasion. Your Excellencies, to that end, we first submit that the preconditions for the court to hear this case are met, namely that the court is able to exercise territorial jurisdiction by operation of Article 12(2)(a) of the ICC statute, and that the case is of sufficient gravity pursuant to Article 17(1)(d) of the ICC statute. This court is able to hear the case by exercising territorial jurisdiction because Article 12(2)(a) allows the exercise of such jurisdiction over individuals who have committed crimes on the territory of a signatory state. In paragraph 3 of the facts, it is evident that Lowlands is internationally recognized as a territory of Panema, a signatory to the ICC statute. Further, Your Excellencies, the ICC commentaries at volume A, 1A, at page 828 has further clarified that the exercise of such jurisdiction does not require, contrary to the defense's submission, consent of the accused state. And this is consonant with how the principle of territorial jurisdiction has applied in general international law, as evidenced in Malcolm Shaw's commentaries at paragraph 534.
Sorry, who is this Malcolm Shaw?
Your Excellencies, he is an eminent jurist in international law, and such authority can be submitted before this tribunal.
What makes him eminent, though, I think, is Mr. President's real question.
Your Excellencies, we know that he is eminent, as he has been considered so by earlier tribunals outside of the International Criminal Court, by other international tribunals. Such as the International Court of Justice, for instance. Your Excellencies, we also submit that the case is of sufficient gravity pursuant to Article 17(1)(d) of the ICC statute. This court stated in the Gaudet gravity decision that sufficiency in this regard relates to examination of quantitative factors such as the number of victims, qualitative factors such as the extent of harm, and even aggravating factors such as the vulnerability of victims, the brutality of the crime, or whether it was motivated by any discriminatory motive.
So is it enough that there are a large number of victims alleged, or do we have to be convinced that there were in fact a large number of victims?
Your Excellencies, this court further clarified in the same decision that at this stage of inquiry, the court only examines the allegations per se, and not the evidence, whether these allegations are supported by sufficient evidence. The latter is a separate and distinct analysis that is undertaken when the courts consider the merits of each charge. Therefore, at this stage, it is sufficient for the court to examine whether the allegations prima facie are grave, and it is submitted that the factors just mentioned are present on our facts.
Sorry, what do you mean when you say the allegations prima facie are grave? I mean, it's clear that the allegations are grave, but surely there must be some level of probability that they were committed, even though, clearly we don't need proof on bounds of probabilities at this point. So what actually is the test?
Indeed, Your Excellencies, it's the mere mention of the crimes are not sufficient. What is then sufficient for the prosecution is to show is that there is some cause to believe that these crimes have been committed, and we show such cause for each of these factors. Specifically, quantitatively, we see that many women were in fact subject to rape, as evidenced by corroborative accounts in paragraph 11 and 18 of the facts. We also see that quantitatively, thousands of lowlanders were displaced, with at least 500,000 people displaced in New Troy alone, at paragraph 9 of the facts. Therefore, Excellencies, quantitatively, a large number of victims were involved. Qualitatively, we saw that a lot of these rapes were undertaken in a brutal fashion, and with some were undertaken in a brutal fashion, with women being held over a number of days, and gang rapes being a large proportion of such rapes. We also found that the museum and archaeological sites were almost completely destroyed. Finally, Your Excellencies, the aggravating factors are present, at least with respect to rapes and displacements. First, with regards to the displacement, with regards to the rapes, they were committed against defenseless women and children among the civilian population, and the brutality has already alluded to it when submitting on the quality of harm.
Could you just clarify, what do you mean by aggravating factors? How do the aggravating factors fit into our analysis of whether this court should take jurisdiction?
Your Excellencies, aggravating factors will be additional factors that the court could examine to determine the gravity of the case, which do not necessarily fall into a quantitative or qualitative analysis.
Okay, so what are the aggravating factors here?
Your Excellencies, the brutality of the rapes.
How is that not a quantitative factor? How is that not already factored into the qualitative assessment?
Your Excellencies, because the qualitative assessment per se does not may not evoke the same sort of the qualitative factor per se only alludes to extent and type of harm, and while there may be overlaps, this court has held specifically in the Gode gravity decision that the manner of rape could itself be considered an aggravating factor rather than a qualitative one per se. Your Excellencies, therefore, gravity is also established pursuant to Article 17(1)(d). We next proceed to the second submission, that the charge under Article 7(1)(g) of the ICC statute should so be confirmed. We submit this on three grounds. First, there is sufficient evidence that lowland civilians were raped. Secondly, these rapes do constitute crimes against humanity under the meaning of Article 7(1), and the militia knew of such rapes, such an attack. Thirdly, the accused bears command responsibility pursuant to Article 28A of the ICC statute. We turn to the first ground of sufficiency of evidence. The burden of proof that the prosecution needs to discharge is one of proving that there were reasonable grounds to believe that the crime occurred. This court clarified in the Ruto and Sang confirmation decision that what was required was real and concrete proof that created a logical reasoning underpinning the charge. while we admit that all the evidence that the prosecution is relying on is indirect evidence, this court has also held in the Ruto and Sang decision that pieces of indirect evidence which are of sufficient probative value when viewed in totality can still sufficiently discharge this burden. And we seek to now demonstrate that this burden is discharged with three key pieces of indirect evidence. First, the UN report referenced in paragraph 18 of the facts chronicled interviews with women in camps conducted during in situ visits, which consistently attest to militiamen committing multiple acts of rape, which were often violent and many of them taking the form of gang rapes. Every woman spoken to by the interviewer had either experienced sexual violence themselves or knew of someone who had experienced sexual violence.
I have two concerns on this point. The first is, do we know how many women the UN advisor spoke to? That's the first problem. The second problem is, this included people who she had spoken to who knew of someone else who said they had been raped. So this is like double hearsay evidence. How do you deal with these two problems?
Your Excellency's concerns are noted, but this piece of evidence would have greater probative value by the fact that it can be corroborated by other pieces of indirect evidence that were later examined. But further, this court had held in the
by what? What is the corroborating evidence here? What is the primary evidence? What is the corroborating evidence?
It's more specifically, is the corroborating evidence you're going to put before us just further statements from other people?
Yes, Your Excellencies, it would be further statements from social media accounts and also a video account of an actual rape, which when viewed together with this account would provide a great enough probative value for these pieces of evidence in totality. But this court had further held in the Bemba confirmation decision that a piece of evidence of this nature, specifically a UN report, won't have probative value because it comes from a neutral agency which had conducted in situ visits with interviewees who by no appearances have been coerced or influenced into giving their accounts.
Well, certainly will have probative value, but the question is, does it have enough probative value? There's no suggestion that this court would disregard it entirely, but does it get you to the threshold you need?
Yes, and in line with that concern, I would be a bit more willing to maybe accept this if that was all the evidence pointing towards the same conclusion. But here aren't there some contradictory statements made from the other side that point to a lack of occurrences of rape, or at least that certainly make the situation look less serious than you're making it out to be now?
Your Excellencies, the contrary evidence that's being made by Midlands is firstly not supported, in and of itself not supported, and merely an allegation that all these pieces of evidence are propaganda.
So why are the allegations not supported and yours supported? They're both statements, right?
Your Excellencies, the statement on the part of Midlands is merely a singular statement that amounts to a mere dismissal of the charges made, and do not do anything further to substantiate those charges. Even if Your Excellencies were to consider the fact that the Security Council had dropped sexual violence as one of the charges, as one of the concerns it had, that could have been motivated by political pressure rather than the fact that the report was not viewed in a good light. Therefore, Your Excellencies, there's no sufficient counter-narrative on the part of Midlands apart from bare denial.
Sorry, where's the Midlands bare denial? Where do I find it?
Your Excellencies, it's at paragraph... I'm unable to assist Your Excellencies on the precise paragraph, but the dismissal took the form of characterizing these claims as Panamanian propaganda.
So that would be paragraph 12, right? When Colonel Brown said this.
Yes, Your Excellency.
And then isn't there something else later on in paragraph 19 that says that when this UN representative went to speak to the prisoners in the presence of the camp commander, then the camp commander recognized that yes, there were a few incidents, but these were dealt with, people had been replaced, and so on.
Your Excellencies, that may allude to instances being dealt with in the camps, or at least in the particular Camp W1. However, the claims that the prosecution advanced is a systematic form of rape that's occurred throughout Midlands, and therefore it's a much graver situation than merely looking at isolated incidences in Camp W1.
And that is precisely my concern, because if what you advanced was maybe just that there had been at least one instance of rape, then your video alone would be good evidence. But if you're talking about a systematic chain of rape all throughout this campaign, and you've got one side saying that these things have happened, and you've got the other side saying that these things have not happened to nearly this standard of gravity, then how are we to take this as sufficient evidence? Because it seems like both sides are telling a different story. We don't know who to believe.
Yes, and to build on Mr. President's point, it's not enough that you have the likelier story, because you are the one who has to make up the case. Even if we say, all right, what the other side has said is just a bare denial, that doesn't mean you succeed, right? So we need to be convinced that we can rely on this report. And although it's true that we can give weight to UN reports, hasn't the ICJ, whose jurisprudence we do consider, stated that we have to look, among other things, at the manner in which the report was made, how thorough it was, how accurate it was, and here we have no information on the method by which this report was generated.
Your Excellencies, we understand, we accept the concerns that you've raised, and we accept that the UN report on its own may be insufficiently probative for us to discharge our burden. But, Your Excellencies, there's no smoke without fire. When the UN report is then viewed together in the context of social media accounts, and also in the context of how one such rape could have occurred in a video, surely it paints a picture that is enough to satisfy the burden of substantial grounds to believe.
Well, no, because there's no smoke without fire, but we need to know how big the fire is, don't we? That is what the whole point of the gravity submission is about. So, although one rape is indeed one rape too many, it may not be enough for us to take jurisdiction over the matter, because we're not a domestic criminal. So it's the most serious of matters. So is this video enough to corroborate this allegation of a widespread campaign, as Mr. President answered?
Your Excellencies, you submit that at the confirmation of charges stage, given the burden of proof that's before this court at this stage of the proceedings, it should so be submitted. And if the concerns that the court has just raised would again be met and adjudicated at the actual criminal trial, where the burden of proof would then be beyond reasonable doubt. But at the confirmation of charges state, the court should err in accepting and admitting this case, confirming the charges, so that the case can proceed, and Your Excellency's concerns will be adequately dealt with, given the burden of proof at the subsequent stage as well.
Okay, so could you just clarify for us, what is the burden of proof at this point?
Your Excellencies, the burden of proof at this point is substantial grounds to believe, which sits in between beyond reasonable doubt in the subsequent stage of the proceedings and merely reasonable grounds to believe in the arrest warrant stage preceding this stage of proceedings. We therefore submit.
Okay, and what has this court found to satisfy this threshold in the past? I mean, you can't decide this in a vacuum, right? Surely you can point to other cases where this kind or this level of evidence was enough for us.
Your Excellencies, in the Bemba confirmation decision, they had used a similar pieces of evidence to find gravity, specifically the UN report that was also backed up by various accounts, second-hand accounts of rapes as well, and those assisted in finding gravity.
But were there differing accounts in that case?
Your Excellencies, there were differing accounts in the Bemba case, but admittedly, Bemba had a larger pool of evidence to work with. But the Bemba judges had also declared that these pieces of evidence were themselves probative enough to discharge the burden, even though there are other pieces of evidence to consider as well. And therefore, that proposition should still be applied in this set of proceedings. Your Excellencies, I see that my time is rapidly diminishing. I would therefore, with your honour's leave, like to submit on the command responsibility that the accused bears under Article 28A of the ICC statute. Your Excellencies, the Taganda decision laid out 3 criteria that needed to be satisfied. First, that the accused had effective control over the perpetrator. Secondly, that he knew or should have known of the crimes committed. And thirdly, did not take reasonable and necessary measures to stop them, punish them, and to stop and punish them. First, we submit that Smith had effective control over the militia. This court highlighted in Bemba that indicia for effective control would include the official position of the perpetrator, the power to issue orders, and the ability to send forces into hostilities. Your Excellencies, I see that my time is up. If I may take a minute to summarize my submissions.
Why don't you have 2 minutes since we detained you quite a lot?
Much obliged, Your Excellencies. We first submit that Smith had both de jure and de facto control over the militia. The de jure control is established by virtue of his position as the commander of the Midlands Armed Forces, to whom the militia's commanding officers also reported
Actually, this part is fairly easy for you. Why don't you skip right to whether he knew or should have known and whether he took measures?
Yes, Your Excellencies. The Taganda decision establishes that Smith would be found to have known if he had failed to attain knowledge as a result of negligence in his duties, where general information had been put to him that would have put him on notice of such crimes, and would have justified additional inquiry, but he had not.
But he did inquire, didn't he? He summoned Colonel Brown. He basically gave him a dressing down, told him to go see to it. Right?
Yes, twice, if I'm reading this correctly. So if you say that, if you're bringing up the concept of negligence of duty, can you really say he was negligent if he trusted his subordinates to take care of this?
Your Excellencies, we would then submit that the inquiry that Smith allegedly took was not a real inquiry, or was not a proper investigation.
Yeah, but that's because he told someone else to do the investigation, right? Isn't that how commanding works? You can't, as a general, you can't investigate everything personally. So you order your subordinate, go investigate it, see that these people are punished.
Or
Is
you
that
need,
negligent?
yeah, sorry.
What do you think he should have done and what he did was wrong?
Your Excellencies, he could have. Firstly, it wasn't clear that he had even ordered Brown to conduct an investigation. All the facts allude to is a conversation about the matter, and it's unclear if this was communicated in the form of a directive to investigate in the first place.
Well,
so that could have been
Colonel
done
Brown
first.
had agreed to investigate. Is it really important whether it was an order? So whatever it is, they discussed, and it seems Colonel Brown said, yes, I'll look into it. So was it even necessary to have an order when the person had already agreed?
I mean, Colonel Brown actually said, I'll see what I can do, right? It's embarrassing and so on. So wouldn't General Smith be given to believe that something was going to be done?
Your Excellencies, that would be insufficient to discharge the legal burdens that he does have as commander, because he had not followed up with that after that conversation to clarify whether in fact the rapes had been stopped or in fact the perpetrators had been punished. And it's unclear if any of those measures were in fact taken up. Your Excellencies, I see that my time is up. If I may, if there are no additional concerns of the bench, I take my leave.
Good afternoon, Your Excellencies. My name is Stella Chen, and I represent the prosecution for today's case. In disregard of the laws of armed conflict, General Smith ordered the systematic confinement of civilians wherever his forces travelled in the lowlands, and showed a similar disregard for the cultural heritage of Panima, leading an attack which devastated a museum and archaeological site, and even taking some of those artifacts back to his home in the Midlands. In light of these issues, I will speak for 19 minutes on 2 submissions. First, that General Smith is liable for the unlawful transfer and confinement of civilians, and second, that General Smith is liable for the destruction and seizure of enemy property. With regard to my first submission, the prosecution proceeds with regard to 2 acts of displacement. First, the displacement of civilians from the suburbs of New Troy into camps, at paragraph 10. Second, the confinement of civilians after the surrender of Old Troy, it's at paragraph 15. With regard to these two acts of displacement, the prosecution will first establish the elements of the crime and then establish Smith's responsibility for the crime. The prosecution must prove three elements of the crime of unlawful displacement. First, that it took place in the context of an international armed conflict, which is not disputed by the defense. Second, that the persons displaced were protected persons under Geneva Convention 4, which again is not disputed by the defense. The only element in dispute is whether or not these transfers and confinements were indeed lawful. And with regard to this, the relevant law is found in Article 49 of the Geneva Convention 4.
So can I check one thing first? Are both sides strictly confined to the content of their written submissions? Are they allowed to depart?
Yes, Your Excellency, but we may not contradict the submissions that we have written.
So you're not allowed to depart?
We may
So
depart.
you're allowed to make additional submissions, but you are not allowed to go against what you've written.
Yes,
I see. So could you just address us very briefly on the protected persons point, because from what you've said, the defense could now come up and raise an additional argument that actually these weren't protected people.
Yes, Your Excellency. Under Article 4 of the Geneva Convention 4, a protected person is someone who finds themselves in the hands of an occupying power of which they are not a national. And in this regard, the occupying power was Midlands, and the civilians who were detained were nationals of Panema and not Midlands nationals. Therefore, the prosecution contends that they are indeed protected persons under the Geneva Convention 4. And the prosecution will now turn to establishing the unlawfulness of this confinement, again but with reference to Article 49 of Geneva Convention 4. It is stated that forcible transfers of protected persons are prohibited regardless of motive, and evacuations may be permissible only if undertaken for the security of the population or...
Sorry, so I'm a little bit confused now. You said first that they are prohibited regardless of motive, but they can be done if they're for the purpose of security. So the second one is an exception to the general
Yes, Your
rule, is it?
Excellency. I apologize if that was not clear. The only exceptions are permissible are if it was done for the security of the population or if it was done for imperative military necessity. And such reasons were not found for both the displacement in New Troy as well as the displacement in Old Troy. With regard to the New Troy displacement, as a preliminary point, the defense contends that this was done for the safety of the civilians, in order to protect them from the armed resistance in New Troy and the conflict between the armed resistance and the Midlands forces. However, this argument that it was done for the civilian safety is not borne out on the facts. At paragraph 10, it is clear that the armed resistance in New Troy comprised civilians who were unwilling to leave New Troy, and there is no evidence that such civilians would have been hostile to their own fellow civilians. Nor is there evidence that the confinement of civilians in New Troy
Okay, hold on, sorry, but does it need to be shown that they would have been hostile to their fellow civilians? Wouldn't the argument instead be that some of these people were likely to take up arms against the invading army, basically, and in the crossfire, other civilians could be injured? Isn't it legitimate to say that we anticipate some conflict with militiamen or whatever, and therefore we want to evacuate the civilians before such conflict erupts?
Your Excellency, that is an alternative interpretation which is also possible on the facts. In response, the prosecution would say that an evacuation of civilians would have to meet a fairly high threshold, and the authority for this would be the commentary to the Geneva Convention 4.
So what do you mean by the evacuation of citizens would have to meet a fairly high threshold?
The danger posed to the civilians would have to be of an immediate nature, and it would not be enough to merely speculate that there would be crossfire involved.
So what would constitute danger? Do you need something to actually have occurred, or is the possibility of danger sufficient?
It can't be the first one, right? Because then you'll be acting after the fact, which cannot be the case.
It is submitted that both the probability of the danger occurring as well as the threat, the intensity of the danger about to be posed, has to be sufficiently grave, An authority for this would be the Jean Pickford Commentary to Geneva Convention 4, which gives as an example a population which is about to be bombed by an enemy. In such a case, evacuation of this population would be justified for their security. And this example may be clearly distinguished because on the facts, there was no immediate and grave danger to the civilians in New Troy, but merely a possibility that they might be caught in some crossfire.
No, that's the thing that I'm having difficulty with. Why isn't the possibility that these civilians would be caught in the crossfire sufficient to prove an immediate danger? I mean, you've got people holed up in their houses waiting to shoot militants that walk by. If that's not immediate danger,
if you did.
yes. And you know, it sounds to me like you have at least a portion of the citizens ready to resist. Looks like with arms, and if that's not immediate danger.
And there were opposing fighters, weren't there? At the end of paragraph 10, it says it had the effect of pushing opposing fighters into those parts of the CBD that were not under the full control of militia. So it's not just a fanciful possibility. There was already armed opposition. Just don't know the extent.
Your Excellency's concern is with the opposing fighters who are already in New Troy, and Mr. President, your concern was whether such fighters would pose an immediate danger to the residents of New Troy. However, on the facts, it is clear that the civilians who were evacuated were not civilians living in New Troy who might potentially be threatened by militants who would be happy to shoot anyone who walks past. In fact, the civilians who were displaced were civilians living in the suburbs of New Troy, and such civilians are highly unlikely to be in such immediate danger as Your Excellencies have proposed.
That doesn't make sense, because it says, second last sentence of paragraph 10, the evacuation of the outer suburbs proceeded over a week. It, meaning the evacuation of the outer suburbs, had the effect of pushing opposing fighters into those parts of the CBD, etc., suggesting that these opposing fighters were originally in the outer suburbs. Wouldn't you agree? Otherwise, why would evacuating the outer suburbs have the effect of pushing opposing fighters into the central business district?
Excellency, it is not clear on the facts where the opposing fighters were located. It is submitted that with regard to Your Excellency's concern about the level of safety and danger required to evacuate civilians, such a threshold is set at a high standard because the very act of displacement was recognized by the drafters of the Geneva Convention 4 to be a traumatic displacement because it involves the removal of an individual from their homes and from an environment with which they are familiar.
So your submission, what you're saying now is that there's a high legal standard, and right now we don't know whether the standard has or has not been met.
Yes, Your Excellency.
So whose burden is it to prove that the standard has or has not been met?
Your Excellency, the defense must show that if they allege that the evacuation was done for the safety of the civilians, it is their standard to meet it. However, the prosecution is preempting the defense's arguments that such a standard has indeed been met.
All right.
Okay. So just to clarify, so you're saying that on this point they bear the burden because effectively they are raising a defense, and so long as you can show displacement, then prima facie you've made your case, and it's for them to show that the displacement was justified. Is that correct?
Yes, Your Excellency.
Okay, but then there's still one thing that troubles me, which is even if they were not in fact or in law justified, isn't there some mens rea element to Smith's individual responsibility? So if he took the view that on the facts as he knew them, it was necessary to evacuate the civilians, then is he still liable, even if he turned out to be mistaken?
Your Excellency, this view of the law is indeed correct. The commander is offered the discretion to determine what he requires to be necessary. However, this requirement is with regard to if the civilians were evacuated because of military necessity, and with regard to the safety of the civilians, the court is still entitled to assess whether or not the civilians were indeed evacuated for their own safety, or whether it was done for some other purpose.
Okay, but that's the thing. Is this question of whether they were evacuated for their own safety really dependent on whether there was a legal right to evacuate them, or is it really a subjective assessment thing? So if the if the Midlands Army, and in particular General Smith, genuinely believed that this was necessary for the civilian safety, if they were wrong in law in that assessment, does that make Smith guilty of this crime? Or is it enough that he had a good faith belief?
Excellency, with regard to whether or not Smith and his forces genuinely believed that it was necessary for the civilian safety to be evacuated, the facts are not clear on whether indeed they did have such a belief.
No, that's not the question. The question is, what is the inquiry? Are we interested in whether they were actually justified? Are we interested in whether they genuinely believed that they were justified? Which is the question we have to answer as a court.
It is submitted that the court must also be concerned with whether or not, on the actual circumstances, there were reasons that justified the evacuation on security purposes. And the reason for this is that it would otherwise open the gates for a commander to allege that he genuinely believed the security of civilians was at stake, regardless of whether or not reasonable evidence was found to support his belief.
Well, if there's no reasonable evidence at all, then the court would have no difficulty rejecting his claim that he had that reasonable belief, right?
That's right. That seems more like a question about how we assess his reasonable belief, whether objectively or subjectively. But if you say that there must have been actual reasons, then that seems a bit strange, right? Because you're asking someone under the pressures of war to have his actions judged in hindsight. And if he fails that bar, then notwithstanding that he was putting in his best efforts for his country, then we hold him to account.
Yes, Your Excellency. With regard to the need for the court to objectively assess the commander's belief, it is submitted that the court should indeed carry out such an assessment, but on the facts, there was insufficient evidence for Smith to believe that the...
Okay, so now you're accepting that the relevant inquiry is as to his belief.
The relevant inquiry is also whether or not he had reasonable grounds for this belief.
But surely that's because the existence or non-existence of reasonable grounds is evidence which would incline this court to find or not find that he had that belief, right? And because if we're looking into his mens rea at this point, because let's say we're with you on the actor's rears being made out, right? We are still interested in whether he can be blamed for this. And when we look for reasonable grounds, the reason we look for whether there are reasonable grounds is because if there are no reasonable grounds, then it's very hard for us to accept his testimony that he had such a reasonable belief. Right?
Yes,
So the ultimate inquiry is still what he believed subjectively, isn't it?
The ultimate inquiry is whether or not what he believed, as well as whether he had reasonable grounds for this belief, and therefore it would constitute both a subjective and objective assessment. Even if Your Excellencies are not with me on the fact that the new Troy displacement was unlawful, the prosecution submits that the old Troy displacement was clearly unlawful because at this point in time, the opposing army had surrendered and there was nothing that the civilians were in danger of, nor was there military necessity to confine them. As my time is rapidly diminishing, if Your Excellencies have no further questions on this submission, I will proceed to the second submission with regard to the destruction and seizure of enemy property. Your Excellencies, it is a fundamental obligation under international humanitarian law to distinguish military and civilian properties. Cultural properties, in particular, are granted special protection above and beyond their status as civilian properties in light of their cultural and historical significance. This charge is with respect to the battle outside of Old Troy, which led to the destruction of an archaeological site on the World Heritage List and the seizure of prized historical artifacts as war trophies. The prosecution will first deal with the argument of unlawful destruction and then continue to the argument on unlawful seizure. The elements of unlawful destruction are first, that it took place in an international armed conflict, which is not in dispute. Second, that the property enjoyed a protected status and that the perpetrators were aware of this protected status, which is again not in dispute.
Is it really not in the dispute? Not dispute. I mean, it hadn't been designated by UNESCO, right? At the time that it was destroyed.
Your Excellency, a designation as a UNESCO, a designation on this list that is in the facts is not necessary for the property to enjoy protected status. All that is necessary is that it enjoys protection under Article 1 of the Hague Convention of the protection of cultural property in event of armed conflict. And the defence does not dispute that it indeed enjoys such protection. The registration that Your Excellency cites is only with regard to a different and higher level of protection, but even with the existing protection, it was sufficient. The defence's only argument on the destruction of cultural property is with regard to whether or not such destruction was necessary because of military reasons. It relies on the
Sorry,
case...
isn't there also a question over who destroyed it? That's an issue too, isn't it?
Your Excellency, it is for the purposes of this...
We've never tried the incidental damage one, so I think I'm skipping it because there's no time.
No, it's because we're responding to the real opponent's memos.
We
Well,
can
alright,
talk
but-
about this later.
Yeah, we'll talk about that later, but just assume for the moment that this is a live issue. Because, I mean, see, even if the opponent, even if they're not raising it, we still have to be satisfied that the Midlands forces were responsible for the destruction.
Yes, Your Excellency.
So, is it safe for us to conclude that, and why?
With regard to the liability for destruction, it is stated at paragraph 17 that the parties are in dispute over who destroyed the museum. However, the prosecution submits that the court may rely on circumstantial evidence to so determine, and the authority for this is the ICTY case of prosecution and Struga.
Sure, what's the circumstantial evidence here?
The circumstantial evidence in this case would be the parties' motivations and prior behaviour with regard to property. With regard to Panema, there was no motive for them to destroy cultural heritage of their own country. In contrast, Midlands, in their invasion, had already demonstrated their disregard for civilian property through destroying farms at paragraph 8 and even flattening buildings in New Troy in order to counter the armed resistance at paragraph 10. Given Midland's prior behaviour and Panema's lack of motive for the destruction, the prosecution submits that there is sufficient circumstantial evidence to infer that this destruction was indeed caused by Midlands.
Well, but even if it was caused by Midlands, doesn't it matter why they caused the destruction? I mean, in a sense, whether the damage might have been incidental or necessary, as compared to what ISIS just did to a bunch of statues, and that's going around social media now.
Your
Is
Excellency,
there such a question?
yes, Your Excellency, there is such a concern. I will, if I may, answer your question and then summarize the rest of my submissions in 1 minute, as my time is diminishing. The prosecution must show that the destruction was not necessary for military reasons, and also show that it was not incidental damage. With regard to both reasons, the prosecution submits that the fact that the destruction was intentional and not incidental is shown by the sheer amount of destruction and how disproportionate it was. This court found in the case of Katanga and Chue that where destruction is disproportionate, it may be inferred that the attacker had intended to hit that target.
Okay, so but there are two problems, right? The first is that here we know, it's in the agreed facts, that the Paneman artillery were dug into the raised ground around the museum. So that fact would seem to maybe rebut that presumption, first of all. And secondly, do we know the proportion? Do we really know there was disproportion? It says most of the historical artifacts have been destroyed. Is that enough to conclude that they did more than they needed to attack the military target?
On the facts, the destruction was indeed disproportionate, even if one considers that the artillery was surrounding the museum, because the archaeological site was not near the artillery. At paragraph 17, it is stated that the artillery overlooked the archaeological site, implying there was a distance between them. Yet the archaeological site was almost completely destroyed, and this shows that the means of warfare adopted by Midlands were indiscriminate and disproportionate.
Or maybe it was just artillery bombardments and counter bombardments. It's not an exact science, right? You're trying to hit them where you think they are, and they're trying to hit you where they think you are. Sometimes shells can go astray.
I mean, realistically, if you're facing an artillery position on high ground, you'd want to destroy it before it destroys you, right?
Yes, Your Excellency. I note that I am out of time. If I may have a minute to answer your questions and then to wrap up my submissions. Much obliged, Your Excellencies. With regard to whether or not it could have been destroyed as part of an artillery bombardment, the fact that there is cultural property involved puts an obligation on the Midlands commander to adopt measures which are proportionate. If he adopts measures which are disproportionate to achieving his military objective, he is not entitled to rely on the defence that it was merely incidental damage. And in this case, even though he was facing artillery, the prosecution contends that he could have adopted perhaps a more targeted method of weaponry and not simply firing shells, which were found in the present case.
Do we know that they had that capability?
I'm sorry?
Do we know that they were capable of more precise targeting?
Your Excellency, it is not found on the facts what weaponry Midlands was capable of, but it is not in the mouths of an aggressive party to contend that he did not have the sufficiently sophisticated weapons to discharge his obligations under international law. Because this would unduly disadvantage parties that do have more sophisticated weaponry systems and give a defense to states with less sophisticated.
Well, no, it would just mean that this court pays due regard to the actual capabilities of the belligerent, right? So if you have laser-guided missiles and you choose instead to shell indiscriminately, then clearly what you've done is disproportionate. But if those shells are your only means of taking out that target, and that target is highly threatening to you, then maybe that is proportionate in light of the resources that were available to the belligerent.
Your Excellency, it is acknowledged that if Midlands indeed had no other weapons available for its disposal, then perhaps it would be proportionate for the shells to have been used. However, on the facts of the case, it is not shown that they had no other means, and in light of the weaponry which is available to an ordinary army in this time, it is inferred that they must have had some more targeted means, even if not as sophisticated as laser-guided missiles. Excellencies.
Okay, I'm sorry, just one last question. Just recap for me again what exactly you are putting forth here as prosecution. You're saying that the destruction was...
Excellency, the destruction of the museum was not lawful because this destruction was intentional and done without military
Why would
necessity.
they want to destroy the museum specifically? In fact, afterward, didn't General Smith say, hey, protect the artifacts? Didn't he then, on your case, take some of these artifacts for himself? Surely this shows that whatever their motivation, they didn't want actively to destroy the artifacts or the museum.
Yes, and also a related thing, if your case is that the destruction was intentional, then this time isn't it you who has to make out what you're claiming, that they had better options but they used these very destructive options, so we should infer that it was intentional?
Your Excellency, the fact that the destruction was intentional may be inferred from more than the fact that it was shelled. It may also be inferred from Midland's complete lack of regard to civilian property in the entire course of the war, as they had previously destroyed civilian properties in all other territories that they had
but how
entered.
does that square with what my brother Judge just asked you about General Smith's take on the artifacts?
General Smith's seizure of the artifacts is entirely consistent with his wish to destroy the museum, as both evidence his attitude of superiority towards Panamanians and disregard for the Panamanian culture.
Oh, but I don't know if you can just mash those two together, because if I have a disregard for my brother Judge's ownership of his car, that could manifest itself in my keying his car. It could also manifest itself in my trying to steal his car. But if my intention was to steal his car, it would make no sense for me to try to destroy it first. Wouldn't you agree?
Your Excellency, General Smith's intention in this case was to destroy the museum and the artifacts, and upon finding that not all of the artifacts had been destroyed, he decided to seize some of them and bring them home to Panama for his own personal use. Hence, the facts may be reconciled in this manner.
I'm sorry, but isn't it in the agreed facts at paragraph 70 that General Smith ordered one of his subordinates, Major Adams, to protect the historical artifacts? So even if he had some bad motive for protecting them, maybe because he wanted some of them for his country home, for instance, it's right then the fact that he did order his subordinate to protect the artifacts. So how is this order consistent with an intention to actively destroy them earlier?
Excellency, with regard to General Smith's order to protect the artifacts, it is submitted that actions speak louder than words. And what indeed happened after he gave this order to protect the artifacts was that the very subordinate whom he ordered to protect them had some of them taken back to his own home, and that other soldiers took the artifacts as well as war trophies.
Well, yes, but none of them, they didn't destroy any of them. I mean, I can see how that goes toward your second submission on this point regarding unlawfully appropriating artifacts. But here we're talking about destruction of the artifacts and the museum. So I'm concerned that you're trying to have it both ways. You're trying to say that on the one hand, they actively wanted to destroy Peniman culture. On the other hand, after they had seized it, they wanted to protect it, albeit for their own use. And it's hard to accept that both of these can be true at the same time.
Excellencies, both of these acts are consistent with their general attitude of complete disregard and disrespect for Peniman culture. Whether they destroyed the artifacts or took them home to Midlands, both show that they had no regard to Penima being able to keep and to appreciate its own cultural property. And hence, it is not inconsistent that both the artifacts were seized as well as the museum was destroyed. Your Excellencies, as I am out of time on this issue, if I may not be of any further assistance to the court, I conclude my submissions.
Would you guys like to give feedback now or continue with the defense?
Do you guys need a break to gather
probably need a
yourselves
break.
for the second round?
Yeah. Why don't you guys tell us whether you want your feedback now so you can try to apply it next round, or whether you'd rather just finish everything and then get everything at one shot?
Yeah, because I mean it's up to personal preference.
Yeah.
I personally always prefer to finish everything first, so that I'm not thinking about my feedback while I do my second subs if I'm doing that. But it's up to you guys.
I think we do everything at once. So
Okay, but let's take a break before
Yes,
definitely.
definitely should take a break.
Sorry I'm late, by the way. There was a series of unfortunate events in my life.
Is it just called oversleeping?
No. something to do with my mum's aircon and a kerfuffle about it not being able to turn itself off, and my mum going, oh no, our bills are going to go through the roof. Then I couldn't get a cab, then there were 2 traffic jams.
yeah, certainly. Would it have been a satisfactory response to say that the whole appropriating of artifact could just be a subsequent and separate fortuitous consideration rather than it being a contradictory event? I could aim to destroy something, see that there's still some of it left over.
I actually think so on the facts, because it would have helped a lot just to point to paragraph 17 and say that the order to Major Adams came after General Smith saw that the museum was destroyed, and that would have solved the problem.
I still find it a bit unconvincing under the intentional destruction point. If you're talking about disproportionate use of force, so you shelled it when you could have used some more restrained method, then that's okay, because then your case theory is basically this was a low priority, you were willing to disregard it in order to achieve a tactical objective. But then afterwards, when you saw, hey, we drove them out and there's still some left, let's take it for ourselves, that's consistent. But if you're going to say they intentionally destroyed the museum, then that's weird lah. Because that's like saying that even though it gave them no advantage against the artillery, they still decided, let's blow that fucking museum to bits. And then afterwards, when they had destroyed the artillery and the museum was there remaining, they changed their mind and said, hey, let's protect these artifacts and take them for ourselves. It's just an intentional destruction thing that doesn't sit very well.
Because that aspect of the case theory came from, I think there was a case authority that said that if the destruction was so extensive, the courts will just say that no, you must have intended this destruction.
But that isn't the same as the subjective intention, which was, I think, what we understood the submission to be earlier. If you're saying that there was no subjective intention, but the destruction is so widespread that we should presume or impute such an intention to the general, that's a bit different, isn't it?
Yeah,
Well, we have to be clearer that we are imputing that intention rather than.
And also, I think that when the means used are inherently fairly indiscriminating, non-discriminating, whatever, then it's a bit hard to accept that it's intentional because these are artillery shells. You're shelling the position occupied by artillery. Some shells hit the museum. Under these specific circumstances, I'm not sure if we can infer from the extent of the destruction that the destruction of that specific thing was intended.
It would be like, in our criminal law terms, it would be like a recklessness versus intention thing,
Yeah.
right? But I mean, if the international courts use the terminology of so disproportionate that we presume it's intentional, then I suppose I can still buy it if you give me authority.
Wait, sorry, hang on. We are both basically kind of going into the feedback without actually going into the feedback.
We're just answering questions.
Sorry.
I cannot.
Nagging.
It's okay. You don't worry about it.
Let's really take a break. We will talk about this later.
Okay, can.
But then, if after you hear the defense, then concerns you had as prosecution may not be fresh on your minds anymore.
Oh, don't worry about it. That's why we take notes. At least that's why I take notes. Nick just remembers everything. He's got like a super memory thing.
That's not really true. But no, I will not forget. It's quite vivid, and you can expect that we'll be asking you about the same issues from the other side very soon.
He has a better memory.
Shall we?
For sure. Like, I can't remember my mountain points.
How long do you
Yeah, how long do you need? How long break do you want?
This one.
Alright, so we start at 2:40.
Alright.